basically maybe produced music, or you've made music, or maybe you've written books. So rights can actually be protected by under copyright. So you register with the relevant body that actually basically protects such kind of works. For example, the Kenya Music and Copyright Board, Music Copyright Board. There's actually also one that actually also deals with the literal works. For example, if you've written books, then you're supposed to copyright them. So I think you've read any book, you'll see on the first page that this particular book is actually copyrighted, and you're not supposed to produce it or duplicate it in any form without the permission of the author. If you see such a message, then just know that that particular book has actually been copyrighted. It basically protects the rights of the writer, such that for example, this particular writer has actually been able to maybe use his own mind, maybe use his own brain. So that is actually an asset. So that asset should actually be protected, such that you could actually maybe have financial gains from the literal works. Maybe you can sell the books, because there are those people who actually basically do writing of maybe books and they just survive. Maybe basically they make their ends meet out of maybe selling the books. So how do they protect their books? They ensure that their books have actually been copyrighted. Or for example, if you have music, then in such a case, it means that no one else can actually be able to use the music without you having to give him permission. For example, if there's a corporate body that wants to maybe use that particular music to maybe do an advertisement, so you actually copyrighted your music, then they can't use it without your permission. You could actually tell them, I want you to pay me millions before you can use my music in your advertisement, maybe on the TV or anywhere. So basically, when you talk about copyright, the kind of works that can actually be copyrighted, they are categorized into two. So we have the works that can be copyrighted under the copyright law, the works that can be copyrighted under the copyright law. So we have primary works, and secondary works, and secondary works. So when you talk about primary works, I can see someone saying I'm too low. I don't know. Am I audible? I can see Immaculate says I'm too low. The others, can you be able to hear me clearly, loud and clear? Or is everyone? You can hear me very loud and clear? I'm audible enough. So I think maybe Immaculate, you can check your gadget, just increase the volume. Just increase the volume. This is Sarah says I'm moving too fast, so maybe I'll be a bit slow. So I can see there's a question from Odhiambo asking, what is delivery app? So delivery app could be under the remedies for a patentee. The remedies for a patentee. For example, if you have found out that basically this particular invention, it was actually involving maybe materials, so they could ask you to basically deliver the materials. So maybe those you maybe have basically taken over the materials of the patentee or the inventor, the materials he uses to, or the material he actually used to make the invention. Then they can actually recover the materials from you. So that could actually be one of the remedies that can actually be given by the court. So the court basically just gives an order to deliver all the materials to the inventor or maybe the patentee of the invention. So maybe this particular invention was actually gotten, or this particular discovery was actually gotten by the inventor being able to use certain materials or maybe use certain machineries. So in such a case, the court can give an order. For example, if you've taken those particular materials or machineries from the inventor, such that you are benefiting from them by being able to maybe come up with products and maybe sell them off. So they can give an order also to basically deliver those particular materials to the inventor, Then there was another one from Jacinta. Jacinta says, is there a difference between compulsory acquisition of a patent and revocation of a patent? So you say compulsory acquisition of a patent could actually arise basically, for example, if you make an invention that is actually quite essential to the society. For example, right now, for example, if you say, for example, you make a discovery of maybe a vaccine for corona, you can see what the government is actually going through with regard to maybe dealing with this particular pandemic. So the government could actually basically acquire that particular invention or compulsorily after maybe a certain period. So you basically patent it or actually protect it, but they'll acquire it mandatory. Of course, it won't be for free. They could tell you basically you enter into an arrangement such that you can actually benefit from that particular invention being used by the government. So it could be acquired compulsorily. For example, if you make an invention that is quite essential to the society, it's something that is actually really needed by the members of the society, and maybe the government wants to support them or actually assist them. So in such a case, they can actually maybe acquire it on a compulsory basis by the government. Then revocation of a patent. So I think in this case, maybe a patent that one just surrounds the circumstances that can actually make maybe a patent to be revoked by the government. For example, it could be maybe an invention or a patent that has been given on something that is maybe injurious to the people in the society. In such a case, it means that it's something that cannot actually be implemented. So they can actually, that one just surrounds the circumstances that can actually make maybe a patent to be revoked by the government. For example, it could be maybe an invention or a patent that has been given on something that is maybe injurious to the people in the society. In such a case, it means that it's something that cannot actually be implemented. So they can actually revoke or actually stop that particular patent from actually being implemented. I can see someone is asking, there are 4 types of intellectual properties. 4 types of intellectual properties. I think we have patents, copyrights, and trademarks. So those are the ones that I know of that can actually be registered. These ones you're actually supposed to register so that you basically protect them. So those are the key 3 types of intellectual properties. Or maybe you could be thinking of another one. You can maybe tell us. You can maybe tell us. So I think we were looking at copyrights. So copyrights, you say the kind of work that you can actually be able to copyright or actually protect can be categorized into 2. We can have primary works, sorry, and secondary works. When you talk about primary works, these are actually basically literal works. For example, if you write a novel, if you write a book. So those are basically mostly in written form will actually be categorized as actually being under primary works as actually being under primary works. So these are basically things to do with something that has actually been authored. It could be a magazine that you're actually authoring. It could be a book, something that you've actually been able to author, and you have actually put it in maybe in a different form. It could be in a soft form. It could maybe you store it on maybe a computer. So if you have actually been able to copyright that particular material, whether in soft form or maybe in hard form, but it's actually something you've actually been able to write or actually author. It could be an article or something, anything that you have actually that's actually been authored by anyone. It could be a magazine, anything that is actually authored, or any article that has actually been authored will be categorized under primary works. So, for example, you basically written an article and you want basically to protect it, then you have to basically copyright it, such that there is not any other person who can actually be able to duplicate it in the future. Such that if anyone else wants to use it, then of course he has to seek for permission. He has to seek for permission. Then secondary works, these actually include things like maybe performances, like music production, maybe broadcasts. So sometimes you've seen, for example, if there's a TV station that wants basically to bring a certain story by borrowing a story from another, maybe TV station, they clearly indicate basically this one has actually been maybe borrowed from Super Sport. So if they fail to indicate, then basically Super Sport can actually come in and actually be able to sue them because they are basically using their content without their permission. So that particular content or broadcast has actually been copyrighted. Or maybe at the end of the news, you'll see they will indicate this news has been brought to you by Citizen TV and it is actually copyrighted. So no one else can just use those particular news that have been aired without the permission or seeking permission from Citizen TV. So we talk about secondary works. These are basically like music production, maybe performances or live performances that you've actually been able to record. So for you to be able to protect such recordings, then basically you have to copyright them such that any other person wanting to use them, he has to seek for a permission. He has to seek for a permission before he can actually be able to use them. Before you can actually be able to use them. So those are the kind of works that can actually be copyrighted. So primary works, so they include authorships or anything that have actually been authored, like books. For example, if you author a book, then you can protect it by being able to copyright it. So no one can actually be able to just reproduce the book in any form, because what normally actually happens, for example, you've written a book, then you find out that someone is actually photocopying. You basically report to the copyrights board. Then they basically follow the law that actually basically guides anything that has actually been copyrighted. So what they do, they take over the matter. And actually, if you have evidence, you give them, they'll take over the matter. They basically try to find out if that particular person is actually truly photocopying your books. So if they find out exactly photocopying your books, then of course they'll take him to jail and maybe fine him, or they could actually ask him to basically pay you for any losses you've incurred as a result of him actually being able to photocopy your books. So in such a case, you just report. When you copywriting, they'll charge you a fee. So they'll charge you a fee of copywriting your written book. Once you actually pay that fee, then of course it is their mandate, such that if you find anyone photocopying your book or duplicating your book, you just report to them. So they have officers, investigative officers, who can actually be able to investigate. So long as you've given them evidence, they try to find out this person who has actually been reported, is this true? So they come with the police. So the police just actually maybe take you and maybe take you to jail. So they'll actually ask you to maybe pay a fine for having been able to maybe duplicate the work of another person without actually seeking his or her permission. His or her permission. So what are the rules that actually govern copywriting your work? So basically, this particular copyright will actually be applied on primary or secondary works. Then it subsists automatically upon creation of the work. So it will start basically operating upon creation of the work, so long as you've actually been able to copyright it. It will actually start subsisting since when you actually created the work. So for example, if you create it, then maybe you register it within a day or two. It basically subsists from the time you actually created the work, Then it need not to be granted or registered. It need not to be granted or registered. So basically what you just need to do is basically to give a copy to the copyright board of what you've actually been able to produce. But once you give the copy, of course, you'll pay a fee. So they'll tell you to deposit a copy of your book. So with them, then of course pay a certain fee. So of course, once you've given that evidence that you produced a book by giving them a copy, then of course you can actually be able to take to them any matter concerning any duplication of your work. Then the subject matter must be original. So it must be something that is original. So you can't, for example, be able to, so maybe you do a song, you seek a permission from an artist, you do his song, maybe in another version. So that one is not actually original work. So you just maybe copy this song and actually done it in another form. So that is not actually original work. So you can't actually be able to maybe copyright it or maybe say it as copyright. In such a case, it must be something that is very original. If it's music, it's very original. Or for example, you basically done a song by basically maybe copying another person's song by basically getting a permission from him, then of course that one is not original work. So it is not a copy of any other form or any other copyrighted work. Then ideas in the mind don't count as copyright. So your idea in the mind should actually be brought out, such that if it is music that you have it in the mind, it must be brought out before you can actually be able to say it can be copyrighted. So just having an idea in your mind, then for example, if you have an idea of releasing a certain music today, then of course you fail to release it, then tomorrow you see someone else releasing almost similar music, then you can't actually be able to say that your idea in the mind was actually copyrighted. So this particular person was actually basically produced the music a day later, has actually infringed on your copyrights, such that it means that those ideas in your mind should actually be brought out. For example, if you have ideas in the mind of about writing a book, then you must actually write the book and release it, such that in such a way, then in such a case, if you copyright it, then someone else basically duplicates it, then it means that you'll actually have infringed on your copyrights. So ideas in the mind should actually be brought out before they can actually be maybe copyrighted. So just having an idea, it doesn't mean that that idea in the mind will actually be copyrighted. Then the duration of the copyright, so it will basically subsist. So this particular copyright will actually subsist for the lifetime of a person plus at least 50 years. So for example, if you've written a book and you copyright it, you'll enjoy the rights of that particular book for your lifetime, and maybe it will actually subsist for extra 50 years. So that is according to the copyright law, that is a requirement. So if it is music, you'll enjoy even if you stay for 90 years, you'll enjoy the copyrights of the music for the 90 years. So in your lifetime, if anyone infringes on your copyrights of the music, then of course you can actually be able to take any action against that particular person. So it will actually subsist for the lifetime of a person plus extra 50 years, or at least extra 50 years. So maybe your children can actually enjoy it for extra 50 years before it can actually maybe be depleted. So in which the first recording was actually made. Then the problem with the duration is that most computer programs have a very short lifespan, and there is no need of protecting them for 50 years or plus. So for example, certain maybe our primary works or secondary works we've been able to release would actually maybe just be relevant for a very short period of time. So even subsisting for that particular period that has been given, it won't actually be realized. It won't be realized. For example, maybe if you copyrighted maybe a particular artistic work, any artistic work you've been able to copyright, but it's basically maybe it will be relevant for just maybe the next 15 years, because maybe we'll be having new programs coming in that will actually make your copyright to become obsolete. So sometimes subsisting our copyright subsisting for that particular long period of time, it can't actually be realized because some of the copyrights could actually become obsolete even before your lifetime or a lifetime of a person has actually come to an end. Then copyright infringement. When you talk about copyright infringement, then this is basically dealing with the work or dealing with the work controlled by a copyright in a manner contrary to the interests of the owner of the copyright without the owner's consent. For example, using another person's music without his consent, then in such a case you've actually infringed on his copyright. Or for example, reproducing someone's authorship or anything that has actually been authored without his permission, then that means that you've actually been able to infringe on his or copyright. So reliefs are available for infringement. So reliefs are available for infringement. Basically, those are remedies that can actually be available. So they are the most obvious ones that can actually be given. So they can actually fine the person who has actually infringed the copyright. They can ask you to pay for the damages, because if someone uses your music without your permission, then of course you could actually incur certain losses. Maybe you might not actually basically sell your music as the way you wanted. So you'll end up making losses of having basically produced that particular music. Or maybe you've done a live performance, then someone just reproduces it and maybe sells it. So you won't actually be able to make maybe enough sales without actually, if anyone has actually basically infringed on your copyrights, because you want to be the only person selling the music, or maybe be the only person who's actually been able to produce the music. So if anyone basically copies your music and sells it, you will incur several losses. So it is quite obvious that if you go to court, if someone has actually basically infringed on your copyrights, then of course the court will ask that particular person who has actually infringed on your rights to be able to pay for the damages. So maybe they could ask him to pay for a fine. They could ask him to pay for a fine, or maybe if he has basically benefited by gaining any profits, they would ask him to basically pay you all the profits. Or maybe if someone has actually been able to, sometimes, for example, it could be maybe someone came and actually, for example, if they find out that he has at his place, that place is actually photocopying the books. He has a copy of all your books there. So such that he gets, anytime anyone wants it, he just takes it and actually photocopies it. So they could actually ask him to basically, or they could actually take over all those particular original works of yours from his premises or place, whereby he's actually being able to infringe on your copyright. For example, if there are books that are stored at his maybe house, they could just do what is known as delivery, take up those particular books and basically now deliver them to the original owner. So they could actually place an injunction, stop that particular person from infringing on your rights or on your copyrights. So basically, when they talk about or that particular question being asked by its infinite or Tate, explain 3 reliefs that are available for a copyright infringement. So they're asking for what are the remedies. For example, if you go to court, they'll actually be able to issue, or how will they actually be able to resolve a problem of copyright infringement. So they'll stop the person, they'll ask the person to pay you damages, they'll ask the person to give you any profits as gains by infringing on your copyright. They could ask him to basically give you all the original works that he has, that he basically uses them. For example, if it is maybe a CD of the music, he just duplicates it or maybe on his computer. So they could actually take over all those computers that he's using to basically infringe on copyrights from his or her premises, or from his or her premises. So someone is asking, what do you mean by search and says? Just from the word search, you search and says. You search his premises. Does he have any of your works without your permission? For example, if someone staying in a house somewhere, then you report that he has actually infringed on your copyright. It could be that maybe he's duplicating CDs of your music, so they are stored at his house. He's using maybe part of your books have actually been stored at his house, or your artistic works, or maybe your authored works. So the police will go there and search and seize and take over all those materials from his place. Take over all those materials from his place. So those are part of the remedies that can actually be given by the court. Evelyn is asking, what does injunction mean? Injunction is basically an order that is normally given by the court to stop someone from basically causing any further damage. For example, this injunction is applied in very many aspects. For example, if you've done the law of tort, you'll find that, for example, if someone has trespassed your land, how do you stop him? If you go to court, they'll give an order that he should never actually step on your land. So they give an injunction order. An injunction is basically an order that is normally given by the court to stop basically a certain action from actually going on. For example, if it is actually someone infringing on your copyrights by duplicating your music, they give him an injunction order to stop him. That order is basically stopping him and telling him that you should actually no longer basically continue to basically reproduce the music of this particular person without his or her permission. Maybe they could give an injunction as the case actually may be still ongoing. So you could actually seek for an injunction order from the court, such that when the case has not actually been determined, this person be stopped from duplicating your work. So that when the determination will actually be made, that's when you actually basically know the final decision. So the court can give an order to that particular person infringing on your copyrights to stop from infringing the copyrights by giving what is known as an injunction order. Just an order to stop a continuance or maybe any sufferance to the affected party. To the affected party. To the affected party. To the affected party. So I think, I don't know if I had sent these notes because I can see maybe some of you had actually read ahead. So I want to maybe look at, or maybe those questions are from the past paper, I don't know. So we have, we've seen the remedies. That's what someone has asked there. Remedies in case of infringement of our copyright. Then the defense, maybe you can look at the defenses. What are the defenses you can actually be able to use in case, for example, you've actually been found capable of being guilty of an infringement of our copyright. So maybe you can say you've got consent. You can say this particular person allowed me to duplicate his book. So that can be a form of defense. Maybe you did that particular duplication or you infringed on the copyright due to public interest. If, for example, if that particular infringement or that particular copyright work is required by the public, or there's a public interest that basically maybe they get a copy of what you're actually infringing on. So due to public interest, you could actually say the copyright is no longer in subsistence or is actually no longer in existence, or maybe it is not actually an original work. You could actually say this is not actually the original work of this particular person, so it can't actually be copyrighted because there was another person maybe who produced the same music. Because we've said for you to be able to copyright, then it must actually be original work, not actually something you've actually copied from another person. Such copied works cannot actually be copyrighted. So you did it in cause of maybe fair dealing. Fair dealing, maybe you are basically using that particular work to maybe bring in, you've seen maybe certain persons on the TV actually basically analyzing music. So they just play the music to do an analysis or maybe bring in criticism. In such a case, you can actually use that as a form of defense. We are just doing an analysis and basically comparing different kind of music. So, for example, you are doing a review, or maybe you did it through maybe fair dealing, but the way you basically used the work of another person was not actually unfair to him. So, for example, if the use of the work is actually in a fair way, then that can be a form of defense. Then in certain circumstances, the state may order the copyright owner to license the work if it is important or for the public interest. So maybe if, you basically, for example, they are saying in the case of maybe health or educational interest. For example, you've done a production that is basically trying to educate people on how they are supposed to protect themselves with things to do with COVID. Then the government sees this particular production is actually very essential. So they could actually maybe convince you just to basically license it. So maybe you don't want anyone else to use it. So they can actually compulsory ask you to license it or allow it to be used by the government to educate people on how they're supposed to protect themselves, maybe from a particular pandemic, or maybe it is actually an educational material. Since this particular material is actually required for public interest, the public really needs it because it will actually assist them. But you, as basically the person who actually produced it, has copyrighted it, and you don't want anyone else to use it. You just want it to maybe stay there, no one else to use it. So it could be acquired compulsorily by the government, or the government would ask you to license it. So when you license it, maybe you could actually ask the licensing to be done, but not for free. You'll be paid maybe a token or something, such that it can actually be used to educate the public, or just basically for the benefit of the public, or if it is actually in the public interest, such copyrighted work be used. Such copyrighted work be used. So Infinix what is asking part of the works that can actually be copyrighted. So you've seen there are primary works and actually secondary works. In primary works, you've said anything that is actually authored, like magazines, like articles in newspapers. When you talk about secondary work, it could be live performances, it could be music production, it could be it could be broadcasts by televisions. Those are the kind of works that can actually be copyrighted. So we can look at trademarks. We can look at trademarks. Trademarks. So when you talk about a trademark, there is basically just an identity of a business or maybe a company. So that particular identity should actually be trademarked or actually be protected under what is known as a trademark. So once you trademark it, then you have actually been able to protect it. No one else can actually be able to use that particular signage or maybe logo. For example, you'll find out that the logo for Safaricom, no one else can actually be able to use it for his or her own benefit because it has actually been trademarked. It is the identity of Safaricom, the logo of Equity Bank. You can't actually be able to use it. Anyone else can't be able to use it. It has actually been trademarked. So before you use it, you have to seek for permission from Equity Bank so that they can actually be able to allow you to use it. So when you talk about trademarks, this is basically any word or sign used to indicate the correlation between goods and services and the owner. It is a distinctive symbol that identifies a particular product of a trader to the general public. So anything that basically identifies a particular company or a product will actually be termed as maybe a logo or a signage. That signage can actually be protected under what is known as a trademark. Under what is known as a trademark. So the symbol can either be in words. For example, you've seen certain companies' logos are just words, or basically they have the logo itself. Then there's words that have actually been indicated. So in such a case, that is basically the signage or the identity of that particular business or maybe product. So you can't actually be able just to use it anyhow without seeking for permission. Because then maybe you could just, for example, you could be using that particular signage for your own financial gains. For example, you could maybe use it, the logo of Safaricom, by maybe putting it on your cloth, just to maybe lie to someone that you're actually representing Safaricom or representing the products of Safaricom. So if you use it in any way without the permission of Safaricom, then in such a case, Safaricom can actually be able to take any action against you because they have actually been able to trademark it or actually protect it. So it's just a signage or an identity of a product or maybe a business. So they'll be protected under what are known as trademarks. So examples of trademarks or things that can actually be trademarked, then we can have maybe signs or signages, letters or numerals. For example, I've told you some logos can actually just be in letters or numerals. can be smell or sense or factory marks. It can be colored marks used in words and letters. It can be available signs or sound marks or maybe soundtracks that identify a particular product. So maybe like songs or musicals that identify a particular product. It can be dimensional signs, e.g. Toyota logos and Mercedes signs. So no one else can use that particular Mercedes sign without the permission from Mercedes-Benz. So you can have maybe Toyota. So no one else can just be able to use that particular signage without the permission of Toyota, because it's exactly their trademark. If you see it on any car, you just know this one is actually a Mercedes-Benz. So that's why no one else can actually be able to use it, because it's exactly their trademark. So it's exactly protected under what is known as trademark. So anyone using that particular signage on his or her products without the permission, then in such a case, we will actually be infringing on the trademark of the other business. So they must be registered for them to be protected. Then the proprietor of a trademark must use it to continue enjoying protection. So you must actually always be using it, or maybe placing it continuously on your products, so that you can actually be protected. So maybe we can look at a few past paper questions, then maybe you can see. Let me just try to get those particular questions from the past papers. Then we can actually also look at law of contract before we can call it a night. So we can look at, I think, November 2019. Look at November 2019 question. Look at November 2019 question 4. Is it 4A? 4A. You can see that 4A, it says highlight 6 types of inventions which might not be patented. So highlight 6 types of inventions which might not be patented. 6 types of inventions which might not be patented. Which might not be patented. So take 6 types of inventions that you think of that won't actually be patented or won't actually be allowed to be registered as an invention. So the most obvious one, the invention should not actually be going against the law or the requirements of the law. So if it doesn't meet the requirements of the law, is actually against any statute in place, then that invention won't actually be registered. So it won't be registered if it is not meeting or it's actually going against any statutory law. So if the invention is actually against any statutory law, it won't actually be registered. Then another one you can actually be able to talk about is if the invention is not actually applicable or can't actually be applied in any way, because you can make any discovery, but it won't actually be applied in any way or form. So the invention cannot actually be applicable in any way or cannot actually be industrially applicable, it won't actually be patented. Then another one you can actually be able to talk about, you said all inventions must actually be new. So if it's something that has already been discovered, or someone else has actually discovered, then it won't actually be patented. Then if the invention is quite too obvious, if the invention is not very useful or it can't actually be useful in any way, then it won't actually be patented. So if it goes against the laws of the land, or that particular invention is actually against the laws of the land, it is not a registerable patent. If it can't be applied industrially, or it can't actually be applied maybe to do any production or anything that's actually be very useful, it won't actually be patented. If it is an obvious thing or something that's already been registered, then of course it won't actually be patented. It can't actually be patented. Then you can see Roman 2, it says list 4 property rights that might be created by a contract over a piece of land. List 4 property rights that might be created by a contract over a piece of land, by contract over a piece of land. So what do you think are the rights that can actually be created by a contract over a piece of land? Of course, you can have mortgages. You can basically enter into an agreement or a mortgage agreement or a mortgage contract by use of a piece of land. So any rights acquired through a mortgage, because under mortgage we have to, it's a contract between a mortgagee and the mortgager, a mortgagee and the mortgager, so they can use the title of the land. You can have a lease agreement. You can have a lease agreement. So a lease agreement or a lease contract can actually create rights over land. So you can talk of a mortgage rights between the mortgager and the mortgagee. So when you talk about mortgage, it's basically where now someone is actually able to use maybe land as a security to be able to get a loan. You can have there's something else we talked about, profit trend rate, basically where you can actually be able to extract anything from another person's land, like crops or maybe soil. You can talk about encumbrances. Encumbrances are other rights that you can actually be able to get from the land. So you can have leasehold. Leasehold can actually create rights over land, can actually create rights over land. Leasehold can create rights over land through a contract. You can have profit apprendre agreeing with another party that you basically extract maybe crops or anything from your land. You can talk about mortgages. You can talk about mortgages. We can talk about encumbrances, having the right of way on another person's land. So that other person can actually be able to allow you to be able to use your land or as a way, then of course it can actually be another right you can acquire over land. Faith is saying, I've not understood how you answered 4-1. So basically 4-1 is asking for, in simple terms, what are the requirements for your patent to be registered? So they're just asking the opposite. Under what circumstances can your patent not be registered? If it is not something new, if it is not anything that is not new, it won't be patented. It is if it can't be applied in any way industrially or maybe to produce anything industrially, maybe products, it won't actually be registered. If that particular invention you've made or that particular discovery is actually against any laws of the land. For example, Kenya has its own laws. So you make an invention that is not actually conforming to those laws, it won't be patented. So that is another reason that you can actually be able to talk about. So basically, they're just asking for the opposite of the requirements of your patent being registered. If it is a most obvious thing, it won't be registered. If it is anything that is not new, it's not a new discovery. It's something that has already been invented by someone else, so they won't register it. Or basically, you can't actually be able to patent it. You can't actually be able to patent it. If it is a very obvious thing, or it can't actually be applied in any way or any form, it could be maybe an invention that is basically maybe causing injury to maybe members of the society. It's the case that invention won't actually be patented. Won't actually be patented. So I can see you're asking not types. So what I've told you are the types. Are the types of inventions that can't actually be registered. if that particular invention is under a type of which it is maybe going against the laws of the land, if it can be categorized under going against the laws of the land, it won't be registered. So what I've just told you are the types that can't be registered. Those are the answers. Then I've seen let me try to look for another one. But if you see any other one, you can maybe highlight it. You can look at with CPA November 2017 question 4A. With reference to the law of intellectual property, discuss four advantages of registering an industrial design. So the advantages of registering an industrial design. Advantages of registering an industrial design. So the advantage of registering your industrial design your industrial design. So number one, you can talk about so that you can have return on your investments. So maybe you've made huge investments, so you can have return on your investments. You can have return on your investments. So basically, your protection will actually contribute to obtaining a return on your investment, such that no other person can actually be able to infringe it and basically financially benefit out of it. So it enhances return on investments. If you make several investments on the industrial designs, if you protect it, no one else will use it. So return on investments is an advantage. Then number two, it gives you all the exclusive rights over the design. So number two, it gives you all the exclusive rights over the design. So as to exclude others from copying it or exploiting your industrial design. Then another way, if you protect your industrial design, it basically strengthens your brand. Your brand will likely be strengthened because no one else will likely be using that particular design to produce maybe any product. So it leads to brands being strengthened. So you can actually identify a particular brand with only one designer. So it strengthens brands. It strengthens brands or a brand of maybe a particular body or corporate body. Then it gives the designer the opportunity to license or sell and having financial gains. So you can sell it. So it gives the designer the opportunity to license or sell that particular industrial design. So that is another advantage you can get. Then another thing it can actually be able to do, it will basically encourage creativity. So long as you can actually be able to know that if I make any design of maybe a product or anything or any industrial design, then I protect it, then anyone will really be focusing on to create more. So it enhances creativity. People become more creative in the society because they know their brands will be protected or their designs will be protected. So it enhances creativity. So that's another one. It enhances creativity. It enhances creativity. Then another one. Industrial design can actually create a positive image. Industrial designs can create a positive image and increase the market value of the company's products. So they create a positive image about the company and create a positive image about the company and increase the market value of its products. Then you can look at November 2016. November 2016, it says question 4B. It says question 4B, November 2016, question 4B. It says highlight four elements. This one, I think we've already looked at it even. Highlight four elements of a patentable invention. What are the characteristics of an invention that will actually be protected? So we've said the invention must actually be new. It must not be excluded by the laws of the land. It must constitute an invention that is not quite obvious, It must be industrially applicable. Then the other says explain 3 types of property in land. Explain 3 types of property in land. Explain 3 types of property in land. You can talk about freehold. You can say freehold. So I think freeholder is one. We explained that you enjoy the rights over the land for an indefinite period of time. You can talk about leasehold. You can talk about leasehold. You can talk about leasehold. Leasehold, you enjoy the property for a definite period of time. So that is another. Then you can talk about property charters. You can talk about property charters. You can say freehold. Freehold. That's one we did not actually discuss it in our notes. Leasehold. Leasehold. You can talk about property charters over land. In this case, we mean any other rights over land which are not actually really freehold. So we can say property charters over land, e.g., buildings, or anything that can actually be extracted from land. Anything that can actually be extracted from land. So property charters over land. Or maybe you can talk about you can say servitude. Then you can actually also maybe just mention encumbrances. Encumbrances. Now freehold, leasehold, property charters over land like buildings, servitude, other interests in land, or maybe you can talk about encumbrances. Then you can look at May 2016, question 7A. May 2016, question 7A, that's from CPA. It says, with reference to the law of property, explain 2 characteristics of a plant breeder's patent. Plant breeders, with reference to the law of property, explain 2 characteristics of a plant breeder's patent. Plant breeder's patent. Plant breeder's patent. So you could be wondering, what is a plant breeder's patent? So I'd say it is a patent granted. A plant breeder's patent is a patent granted to a breeder of new variety of plants. It's a patent granted to a breeder of new variety of plants. It's a patent granted to a breeder of new variety of plants that give that give the breeder exclusive control over the seeds, cuttings, over the seeds, cuttings, divisions, and harvested material, of the plant for a number of years. So long as you've actually been able to maybe make an invention or maybe a new variety of a plant, by being able to breed it, then you can get what is termed as a plant breeder's patent. So it is a patent granted to a breeder of a new variety of plants, which gives him the exclusive rights, or control over the seeds, cuttings, divisions, or harvested materials of the plant, So any harvest out of the plant, you can't be able just to use it. You have to get the rights from the patentee or the breeder of the plant. So that is what we mean by that. So they're asking for two characteristics of the plant breeders. So number one, the breeder must give the plant an acceptable denomination or generic name. The breeder must give the plant an acceptable denomination or generic name. The breeder must give the variety of the plant an acceptable denomination or generic name, which must be used by everyone marketing the plant. The question is May 2016, question 7A. May 2016, question 7A. So you said the first one, the breeder must give the variety an acceptable name, generic name or denomination, which must be used by anyone who markets the variety. Then the patent rights are granted by established national offices. The rights of the patent are granted by the plant variety rights are granted by national offices, by established national offices after examination. If the plant meets the set criteria, Then another one can talk about breeders can bring a suit in a court of law. Breeders can bring a suit or take action in a court of law, to enforce their rights. Breeders can bring a suit in a court of law to enforce their rights. Breeders can bring a suit in a court of law to enforce their rights. Then we can look at the last one before we start something on law of contract, just in the next 15 or 20 minutes. So the last one we can look at is November 2015, question 4A. It says, summarize 6 ways in which a lease agreement might be terminated. Summarize 6 ways in which a lease agreement might be terminated. So there are several ways in which a lease can actually be terminated. We looked at them through lapse of time, through agreements, destruction of the subject matter, frustration, merger of the parties. For example, if the tenant merges with another tenant, it can come to an end. Through surrender, one of the parties actually surrendering. Through forfeiture or cancellation by the landlord. So you can have lapse of time. When the time for leasing a property comes to an end, that particular lease agreement will come to an end. Through an agreement, or maybe just through a notice by any of the parties, you can notify your landlord that you want to exit this premises. Through merge of the parties, maybe the landlord merges with another one, so it means a new lease has to be drafted. Through frustration, or maybe destruction of the subject matter through frustration. So the building someone is actually staying in is destroyed. In such a case, they won't be the subject matter for creation of the lease agreement. Through forfeiture or cancellation by the landlord, for example, if the agreement allows that the landlord can actually basically forfeit or cancel that particular lease agreement. For example, if you fail to pay your rent, then you can cancel that lease and actually evict you from the premises. Evict you from the premises. From the premises. So we can end there. We can end there with the law of property. So there are those who are actually asking about law of contract. Law of contract. So basically, we talk about the law of contract. Then, of course, basically law that actually regulates contracts or gives guidelines to do with how contracts are supposed to be formatted or maybe crafted. So in this case, a contract is just an agreement between parties. It's just an agreement between parties, or basically being able. One is actually basically to fulfill an obligation for the other one, and the other one is actually basically able to pay what is known as a consideration. So in this regard, when you talk about a contract, it's just an agreement between parties. But this particular agreement, it has certain essentials so that it can actually be categorized as being a contract. So it's just an agreement, but it has to meet certain essentials. So for example, if you look at May 2016, question 3B, they're asking, explain 4 essential elements of an enforceable or a valid contract. This basically means that if these particular elements actually exist or characteristics actually exist in an agreement, it will be termed as being a contract. So a contract is simply an agreement between parties. But for it to actually be termed as a contract, it has to meet certain essentials. So if you look at that particular question, May 2016, they're asking, explain 4 essential elements of an enforceable or a valid contract. 4 essential elements of an enforceable or a valid contract. So that is the first thing that should actually be able to know about contracts. What are the essentials? What are the key characteristics that must actually be in existence for an agreement to be termed as actually being a contract? So first of all, it must actually have what is known as an offer and an acceptance. So we are saying that the 2 parties There will be two parties under contract entering into an agreement. This agreement must meet certain essentials before it can be termed as actually being a contract. So it's an agreement between two parties. These two parties, they will be termed as the offerer and the offeree. So this is the one who basically gives the offer. Because we are saying the first key essential that must actually be in existence, there must be an offer and acceptance. So this one, the offerer is the one who will actually make the offer. For example, Summit is actually offering you basically tuition. So of course, for the agreement to be created, you have to accept. How do you accept? By being able to register as a student. If you fail to register, then of course there is no agreement that is actually going to exist between Summit and you as a student. So the first key element that must be present in contract should actually be there must be someone giving an offer, one of the parties, and of course the other party, the offeree, accepting. So offer and acceptance is one of the key essentials or elements that must exist in an agreement for it to basically now turn out to be what is known as a contract, or create what is known as a binding contract between the two parties in a contract known as an offerer and an offeree. So an offer, we normally say it must actually be a lawful offer. It must be something that is actually allowed under the law. You can't actually offer something that is basically against the requirements of the law. For example, offering drugs. So drugs are actually prohibited under the laws regulating maybe citizens in Kenya. So this particular offer you are giving, giving you tuition by some is actually something that is actually allowed under the law, education or provision of educational services. So this particular offer must actually be lawful. Then of course it must actually be accepted by the offeree. So basically, we talk about the law is something that is actually basically allowed, maybe the law of contract or maybe any law regulating that particular kind of a contract. So basically, an offer is basically something that will be given by the offerer. What is he actually giving? Then of course you have to accept. So he could be giving goods. He's offering you goods. So that will be termed as an offer. Under sale of goods, we term the offer of goods as basically the offer. You as the buyer, you become the offeree. Then you basically accept. When you accept it, basically means you've taken the goods. You agree to take up the goods. Then there must be a lawful consideration. Lawful consideration is another key essential element. So what is the consideration the other party is actually basically paying? So Summit is giving you tuition as the offer. What are you paying? You pay school fees. So that is the consideration. So it's the price that will actually be paid under the contract. So it's basically the price paid by one of the parties for promise of the other. So Summit is promising you to offer you tuition. You pay the price. The price will actually be the consideration, which is school fees. So there must be a consideration that is being given by the other party. Of course, it's just like the other way around. You are paying fees as your offer in this case, and the consideration being given by the school is to give you tuition. So there must be a lawful consideration. You can see the term lawful is very key. It's something that is actually, that consideration you are giving is something that is actually basically allowed under the law. So that's the other key essential element that must actually be present for a contract to actually be formed between two parties. The other one is for the capacity of the parties. Do the parties have the ability to be able to enter into a contract? In this case, for example, can an underage or a person who's actually below 18 years be able to maybe be involved in a contract of purchase of land, entering into a land purchase agreement? That means that that particular party entering into this offer and the offeree, the two parties, must be having the capacity to be able to contract. For example, when you learn more about contracts, you find that, For example, there are certain initiating factors that will likely make one not to be able to enter into a contract. For example, an insane person, so they're actually basically prohibited from entering into maybe contract. They can't enter into contract. For example, underage, or for example, persons who have not attained the majority age, they can't enter into contract. But of course, there are exceptions if they are acquiring things like necessaries. So you can't deny a child to be able to maybe buy food because food is unnecessary. So in a nutshell, what we are saying, the parties entering into the contract must be having the capacity or the ability to be able to enter into the contract. So have they attained the requirements of being allowed under the law to be able to enter into the contract? So when you talk about capacity, the parties in the agreement must be competent to contract. Otherwise, it cannot actually be enforced by the law. For example, if it is discovered that, for example, you entered into a land sale agreement with an underage, then of course he fails to pay you, then of course you'll find it very difficult to be able to maybe claim your money from the underage because he does not have the capacity. It can't be enforced under the law. That kind of an agreement or contract can't be enforced under the law because the parties do not have the capacity. Maybe he's an insane person or his thinking capacity is not actually proper. So you can't enter into an agreement with such kind of a person. So another key element that must be present for a contract to be created between parties, the parties must be having the capacity to be able to contract. The other that we normally say that must be present, there must be free consent. Free consent. Free consent, basically you enter into a contract willingly. So you must not actually be forced to enter into a contract. So you must basically enter into a contract through what is known as free consent. Either through without being coerced, or maybe through undue influence, or maybe you could actually enter into a contract through maybe frustration, being frustrated by maybe your senior, maybe it's your boss at the work. In such a case, you've actually been forced to enter into the contract. So there's no free consent in entering into the agreement. In such a case, that particular contract or agreement won't actually be valid, or it can't lead to what is known as a valid contract between parties. Then, of course, there must be a lawful object. So the subject matter of the contract must be something that is actually very, very lawful. So the formation of the valid contract is necessary where, or this one is actually very necessary because what you actually basically may be negotiating over, is it something that is very lawful or is it something that is actually allowed under the law? You could be negotiating over something that is basically outlawed by the law. For example, you are negotiating over the sale of drugs. So sale of drugs is not basically outlawed by the law. So the object being involved or creating the agreement or negotiations should be a lawful object. So it should actually be a lawful object. Another one that is very key, there must be possibility of performance is actually a key essential element for a valid contract. Is it possible to be able to perform that kind of a contract? For example, you are entering into an agreement that maybe you want to create something that's quite unimaginable. You want someone to basically create rain. Is it possible for someone to just create rain? Is it possible for someone just to create a human being like God? Not possible. Not possible. Not possible. So there are things that certain agreements that can't actually be performed. Those kind of an agreement can't actually lead to a contract. So there must be a possibility of performance. It must be something that you can actually be able to perform or be able to deliver. For example, if we are entering into an agreement that I likely to be able to teach you the whole syllabus of business law within maybe 2 days, is that one actually very possible? It's not possible. There's no possibility of performance. I can't actually be able to deliver all the contents of business law within maybe two days. In such a case, there's no possibility of performance. That kind of a contract or an agreement won't actually be a valid contract. So there must be possibility or the parties being able to fulfill their obligations under the agreement. For example, I'm entering into an agreement with you that maybe you you are going basically maybe to pay for certain services which are supposed to maybe go at maybe a lower price, but I give you an exorbitant price which you can't be able to deliver. This is a case you won't actually be able to pay for maybe the so possibility of performance under any agreement is actually very key for an essential contract to be created between the offerer and the offering. Then another one that must actually be present, it is an intention to create what is known as a legal relation. Intention of creating a legal relationship between the parties, a legal relationship between these particular parties. That particular relationship that will likely be created henceforth between the parties, it must be a relationship that is actually allowed under the law. It is not actually prohibited. For example, employing a minor, entering into an agreement to employ a minor. So minors are not actually allowed maybe to be employed maybe until they attain the age of majority. So that kind of an agreement or kind of a contract won't actually be valid because it is not a legal relation that is actually being created between the two parties. So these are the key elements that should actually be present in an agreement for it to be able to be leads to what is known as a valid contract. But just know under a contract there are two parties, the offerer and the offering. So they enter into an agreement. That particular agreement will meet certain essentials. It means that those particular essentials that it can actually be concluded that it is actually a valid contract. There must be an offer. One party gives an offer and the other one actually accepts the offer. The other one accepts the offer. There must be a lawful consideration. The capacity of the parties or the ability of the parties to be able to enter into the contract. For example, we've said underage or minors cannot actually be able to enter into contracts or insane persons. But of course, there are exceptions. For example, if they are acquiring necessaries, if an insane person is actually acquiring necessaries, you could be asking what are necessaries. Necessaries are actually things he can't actually be able to do without. For example, food. Then, for example, if he walks into the supermarket, he picks something, then he pays for it. Then you can't actually deny to sell to that particular insane person the food because he's actually acquiring what is termed as unnecessary. Maybe clothing, maybe shelter. But of course, when you talk about necessaries, for example, there is an argument before a court that there was no valid contract because that particular contract was actually entered into by a minor. But this particular minor was acquiring food. So they look at this particular food, is it an essential? So there are certain foods that are maybe luxurious, or maybe certain clothes that are maybe luxurious, they're not really essential. So the court has to assess these particular things acquired, are they actually necessary? It could be food, but it's just luxurious food. Maybe things this particular person can maybe do without. So those ones won't actually be categorized as being necessary. So these are the essentials that must actually be present for a contract to be created between the parties. So performance, the ability to perform, lawful objects, capacity of the parties or the ability of the parties to be able to enter into the contract. Then lawful consideration. There must be a consideration. There must be a price the other party is paying. So it is not normally for free. You look at all kinds of contracts. There must be a consideration. Whether it is sale of goods, if you buy goods in a shop, you pay for the goods. That is a consideration. You actually basically pick, for example, you pick the loaf of bread and pay the price, which is actually the money. So there is usually a consideration that is normally paid by each and every party or the parties in an agreement, either the offerer or maybe the offerer. So there must be a lawful consideration. Then free consent. You must not actually enter into a contract by actually being coerced or maybe forced to enter into the contract, being forced to enter into the contract. So I think that's all about the essentials of a valid contract. So it was tested in May 2016, question 3B. Also in May 2015, question 1B, it's a common question. It's a common question. It's a very common question. It's a common question. Basically, another thing you need to know about contract is how they can actually be discharged. So look at how they can actually be discharged. When they talk about discharge, sometimes they say termination, or how do they come to an end? Another thing you need to actually to be able to know, because I'll go through them quickly in our next class, is remedies for breach of contracts, for breach of contracts. What are the remedies that you'll likely be able to get? For example, right now, if you had paid your tuition fee at Summit, then they fail to deliver on the tuition, what steps can you actually be able to take, and what can the court be able to decide in such a case? So they can either give an order for specific performance, they just force the institution to deliver the tuition. They can ask them to pay for the damages you've actually incurred for them failing to teach you. Maybe you failed your exam, you're supposed to pay another exam fee. So they can ask them to pay for the damages or all the losses. They can actually do what is known as, for example, you perform the contract, someone has performed the contract partially and you've not paid him. For example, you could hire someone to build you a house. Then, of course, it reaches a certain point, then you terminate the contract, you as the employer. In such a case, you are supposed to, that person, if you fail to pay him, he basically seek for what are known as, or basically can actually go to the court and the court orders for what is known as quantum merit. Quantum merit, basically pay for the quantity of work that has been performed. Pay that particular person up to the level he has actually been able to deliver up to. You can have specific performance, you can have quantum merit as another one. You can have an injunction. For example, if someone is performing a contract not according to the ways we had actually agreed, the court can give an injunction. So it's a remedy they can actually be able to give. They can actually be able to give an injunction to stop the continuance of the performance of the contract in the way this person is actually delivering. You can actually maybe cancel the contract. For example, with the agreement, there's an allowance for you to be able to cancel it. You do what is known as the rescission of the contract or cancellation of the contract. It's just like that agreement of a landlord and a tenant, a lease agreement. The landlord can decide to cancel it, or basically someone is not basically paying the rent on due time, so you can cancel it. So those are some of the remedies that can actually be present when someone has actually breached his requirements in an agreement or in a contract. So when you talk about a contract, just know that it's an agreement between parties. Those parties will basically just agree on their terms and conditions. So maybe supposed to know something about what are terms and conditions, but we'll brush through them before we can start another topic. Another topic maybe contract of insurance. Maybe we look at contract of insurance just after maybe doing a summary of this and looking at a few questions in our next class. Then we can start contract of insurance. It's a contract between two parties, the insurer and the insured. So we see what are some of the terms and conditions, and what are the remedies in case of there is a breach under the contract of insurance. So this is what we'll actually be able to go through in our next class very quickly by looking at different questions. Already we looked at a question that looks at the valid essentials, which is actually the introduction of this particular topic of law of contracts. So I think we can end there today. So unless there's Jacinta who was asking here, conditions that are valid, conditions that are valid in an easement. In an easement, conditions that are actually valid in an easement. So of course, we say there must be the dominant and the savient tenement. You must have the dominant and the savient tenement. Then the dominant and the savient tenement must not be held by one person. This was actually in the notes. If you check the notes on easements, you'll be able to see the characteristics of an easement. So there must be the dominant and the savient tenement. The dominant and the savient tenement must not actually be held by one person, or must not be occupied by one person. There must be different persons. Then the easement must accommodate the dominant tenements. So the easement must accommodate the dominant tenements. The easement must be capable of forming the subject matter of the grant. So they are just in the notes. You can actually be able to check. You see the answers there. So I think these notes of law of property, I'm just going to share immediately so that you can actually be able to have a look at them. So I think we can end there today. So unless there's a pressing question, you can ask.